The story now, the Takatso consortium has been cleared for takeoff. The Competition Commission says it can go ahead with its 51% acquisition of South African Airways. The remaining 49% will stay in the hands of public enterprises. But the green light comes with some conditions, including divestiture as well as employment. So let's find out more from Tamara Paremoer, who is the head of mergers and acquisitions at the Competition Commission. Tamara, thank you so much for your time and a very good morning to you. Let's talk a little bit about the decision here of the Competition Commission to clear for flight, so as it were. What were some of those informed decisions? Because if we have been following this particular merger, it's been one that has been marred with a lot of uncertainty, but also uncertainty from a premise of who exactly is involved and whether or not the deal has been transparent enough. And I think the transparency of it has been one that has been quite criticized over time. But where have we been and what led to this decision?
Good morning, Faith. So I'll start with the divestiture condition. So the matter was filed with us in June 2022. And essentially, it was a proposal that a consortium called Takatso, but comprising of Herrick, Global Aviation, and a firm called Cyrenix, would acquire 51% of the shares in SAA, with, as you correctly said, the DPE retaining the 49%. The problem for us arose because Global Aviation operates the Lift brand. So you would know that this is one of the recent entrants into domestic passenger airlines. And this is a highly concentrated sector. We have very few airlines at present. So essentially our concern was that a competitor and a growing competitor to SAA, who is also growing at this stage, would essentially be linked by this transaction. Essentially, Lift would have insight potentially into SAA's commercially sensitive information. And the real concern here is that this would troll competition and it might not give consumers the competitive and efficient markets that they deserve. So what we said is that the transaction is conditional upon these minorities exiting from the Takatso consortium, and they must fix that problem first before they implement the transaction.
Is there concern, though, regarding how exactly this will be implementable, and especially when it comes to the capital aspect of it? I mean, 51%, 49%, that is something obviously to speak about, but never mind that. That would also require a lot of capital investment to be able to actually see South African Airlines actually hit the airways once and for all in an efficient, sustainable manner. And we've seen over time, over the past 20 years, unfortunately, that has not been the case. So from an investment perspective and from a capital injection perspective, what does that mean now on behalf of Takatso, as well as what does that mean now on behalf of government?
So I know that the Takatso spokesperson has spoken to the ability of the consortium to raise funds. That is something that we leave for them, right, to resolve, also with the other shareholder, DPE. Really, at the core, the Competition Commission was concerned about these effects that could chill competition between airlines. And also, of course, from a public interest perspective, what would happen to employees of SAA. And really, our investigation is really honing in on those competition concerns and how they can be remedied.
Let's speak a little bit about the employees, Tamara. I mean, let's talk a little bit about those particular conditions that have been set, because again, employees, when it comes to SAA, have been in the dark for so long, especially when it was also during the business rescue process. It looked as though, a lot of them had not been paid for months on end, waiting for some kind of a clear green light or even communication from the likes of SAA, which unfortunately they never really received. So now that you've stipulated these kinds of conditions, what does it mean? Do those who, or those that are currently employed, do they keep their jobs? Those who were previously employed, are they going to be then absorbed within the company itself? What does it mean for workers?
So the Competition Act is quite clear that when we look at transactions, so mergers and acquisitions, we should not only consider competition, but also the effect on the public interest, an important one of these being employment. In this transaction, we did have concerns. There were some indications that there might be some retrenchments, the airline is emerging from business rescue, etc., etc. But for us, you cannot necessarily achieve efficiency at the expense of workers. That shouldn't necessarily be accepted as the baseline. So we did interrogate where these possible retrenchments would come from, whether there was a rational process followed in identifying them. And what we found was that there was insufficient evidence that this would be justified. So we did propose that the tribunal accepts a condition, or imposes a condition rather, to say that workers should be protected for at least 5 years following the implementation of the transaction. And this was really just to give certainty to an important constituency as well, in terms of the Competition Act.
So are these workers now that are within, that are currently working for SAA, or does this also include those workers, for example, that were retrenched during this particular process? So is it the ones that are currently within the system, or are we going to bring back everybody that was ever worked for SAA and maybe have been affected by this merger, or have been affected by the business rescue process, that they must come back?
So because our process is really triggered with the merger filing, we really do look at the situation that applied at that time. I mean, of course, there are times when you would look back, etc. But in terms of employment, what we were looking at is employees who are currently employed in the business, and the condition would certainly apply to them.
Let's talk a little bit about, Tamara, what is to happen next?
In terms of the competition process, the Commission has concluded an investigation. It was about 11 months. So we then made a recommendation to the Competition Tribunal. So the Commission is essentially the investigative arm of the tribunal. We go to the tribunal and present our analysis. The tribunal would be able to ask questions, call witnesses if it deems fit, and it would then make the final decision, as this is a large merger. That decision could be the same as the Commission, but the tribunal does, of course, have the ability to decide the conditions should be slightly altered. Perhaps they would want to add additional conditions if they identify additional concerns, etc., etc.